Thank you, everyone, for joining us. I would like to welcome you to U.S. Supreme Court Justices. Today, we will be discussing the 6 women who have been appointed to the United States Supreme Court. And I'm very excited to welcome Tauya Forst, Professor of Justice Studies at the College of DuPage. Professor Forst has her law degree from Northern Illinois University and is an expert in restorative justice, repairing the harm caused by crime and community restorative practices. So thank you for joining us. Very excited for tonight. I know there is a lot of information to go through. So we are going to let Professor Forst to pretty much go through the entire presentation. And if you have a question, put it in the chat at any time. We'll get to those at the end of the program. However, this program is being recorded. We will have it up on our YouTube channel probably tomorrow, and it will be up for about 2 weeks. So look forward to that as well if you missed something. All right, I'm going to turn it over to Professor Forst. Thank you.
Excellent. And we want to make sure that we understand that we have to go to the court. So we're going to take a little bit of time. We're going to transform ourselves over to the court. And first, I'll just get my screen set up. You'll see this portion for a little bit, but bear with me. And here we should have it. Let's see.
Looks great.
Okay, we're all set. So I want to encourage you that our time together will be pretty interactive. I am Professor Tauya Forst, excited to be here with you today, and hope that you receive something from our programming. So if you would just bear with me during our time together, I'll ask you to do some interactive things, perhaps use the chat, so stay close to that. Tell me some of your thoughts about individual issues and concerns with the court, and our time together should go quickly and smoothly. So bear with me. Oyez, oyez, oyez. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. All persons having business before this honorable court, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. That is simply my way of saying welcome to the Supremes of Justice, the women in the Supreme Court. And during our time together, I wanted it to be very clear that we're transitioning to how the court operates and who's among those who may have some interesting facts for us. So first, as I always do, we're celebrating women, and although it isn't Women History Month, as your favorite librarian shared with me, Jamie, that we should actually speak about and learn about women all of the time. I too agree. So I wanted to share 2 women with you today. April 11, 1908, Jane Boland, and she died in 2007, was the first African-American woman to graduate from Yale Law School in 1931. She also was the first to join New York City's Bar Association in 1932. She was the first to join New York City Law Department and the first to serve as a judge in the US when she was sworn into the bench of the New York City Domestic Relations Court in 1939. This will go along with our time together because we'll start to talk about first, something that I think might be of interest, but my hope and desire is that we move beyond first and that you start to see many. The second woman that I'd like to share with you today is a woman by the name of Annie Dodge Wanuka. She was born April 11, 1910, just 2 years after our first woman, and she died in 1997. She was elected to the Navajo Tribal Council from 1951 to 1978, and she worked on tuberculosis epidemic using Navajo and Bureau of Indian Affairs ideas. She demanded funding for child health programs and was awarded the Presidential Medal of Freedom in 1963. So those two women are women that I think you should know. All right. Sure you are excited to get started. So I hope that this is not coming up. Let me just make sure. Here we go. What is on the docket for tonight? Understanding the Supreme Court of the United States, introducing the Supreme Court of the United States, introducing the women Supremes of Justice, and of course, after we've gained all of that knowledge, understanding their impact. I look forward to sharing this information with you. So without further ado, we'll move forward. What does it look like for one to be a part of the Supreme Court? In very general terms, the authority for one becoming a Supreme Court justice actually began with the Judiciary Act of 1789. And in Article 2, Section 2, Clause 2, the president has the authority to actually nominate someone to fulfill a seat on the Supreme Court. Now, that is done after the president vets with the Senate. Article 3, Section 1 talks about how the court and its inferior courts will be set up. Once that occurs, the president's nomination, that moves to the Senate Judiciary Committee. There will be a vote and a recommendation after that of accept, reject, or no recommendation. And then it goes to the full Senate for a vote. Once confirmed, each and every person becomes a member of the Supreme Court of the United States. Now, it's interesting to note this term packing the court is one that I think is a little bit loaded and possibly may have some issue with its validity. Because in fact, the Supreme Court has had varied members. When the court started in 1869, when the court started in 1790, there was no set number of justices. And in fact, that continues to this day. So I'd like to tell you kind of how the justices have evolved over time. In 1789, there were 6 justices. 1807, there were 7. 1837, there were 9 justices. In 1863, we had a total of 10 justices, our all-time high, except for a little bit off time in the 1930s when we tried to elevate it to 15, but that's another story. In 1866, there were 7 justices, and finally in 1869, there've been 9 justices. Now, that box that says set at 9, it actually means that since 1869, there has been 9 justices. However, there is no constitutional provision that says that the number needs to rest at 9. What I think you might find as an interesting fact is on March 23rd, 2023, Senator Ted Cruz actually reintroduced a constitutional amendment called Keep 9 Amendment to cement the Supreme Court justices at 9. This was first done in introduced in 2021. It did not, obviously it did not pass and was not ratified, so it's been reintroduced. But this concept of packing the court is one that I think should not be. Now, can we increase the number? Of course we can. Of course, if we have 9 justices, that then would mean that we have 1 Chief Justice and 8 Associate Justices. So that's how and the way that our court is comprised. I love this picture because it really gives you sort of the full effect of what the court looks like today. This is actually the Roberts Court, and the Roberts Court was seated in 2022 and will complete their term in 2023. They started in October, the first Monday in October, and will end in late June, early July of 2023. Chief Justice Roberts in the center is who leads this court. And each one of your justices, as you read their name, you'll actually see underneath their name what president nominated them and what year they took the bench. When you normally see a picture of this statute, you will see the most senior justice to the left of the Chief Justice. And that, in fact, is the case here. So Justice Thomas was seated in 1991 by our first Bush and has been there ever since. So he is the most senior member of the court. Now, we call this the Roberts Court because each and every court actually takes the name of the Chief Justice. So prior to this, we've had the Rehnquist Court and the Warren Court, the Berger Court, some of those courts you may be familiar with. At this time, some interesting facts about our justices. I like to talk about Justice Byron White, who's not pictured, but who is the only justice in our history who made it to the College Football Hall of Fame. So that's his claim to fame, and we're very excited for Justice White. Something that I think you might consider or be thinking about is how we determine seniority on the court. And when justices are seated and the day in which they're seated, that actually establishes their seniority. But take, for example, if two justices are seated on the same day. When that occurs, the justice seniority is determined by age. So on January 7th, 1972, Justice Powell and Justice Rehnquist were both sworn in at the same time. Of course, Justice Rehnquist was older, and so his seniority was determined by his age. Something else that you might consider is what and how much were justices, how much did they make originally? So again, we started our journey with justices in 1790, and in 1790, our Chief Justice made how much? Just $4,000. And our associate justices made $3,500. Now, this is quite interesting. It may be a little bit of a leap for you to know that today, our Chief Justice is recorded at making $286,700, whereas our associate justices are at $274,200. That's really, I think, quite a huge gap. But if you consider what our justices could make if they were on the open free market, right, in private practice, it would be astronomically more. So we thank our justices for their service to our country. Something else that I think you might find of great interest is that most of our lady justices pictured here actually clerk for previous Supreme Court justices. So Justice Coney Barrett, who, by the way, only goes by Justice Barrett, and I'll refer to her in that way later, clerk for Justice Scalia, Justice Ketanji Brown Jackson, actually clerk for Justice Breyer, and Justice Kagan, clerk for Justice Thurgood Marshall. And each one of their judicial philosophies were impacted and shaped in some way by those who they clerked for. One last fact before we leave the Roberts Court. It's also interesting to note that Justice Gorsuch, second from the left, is the only justice who actually was on the bench during the same time that he serviced someone, the same justice that he clerked for. And of course, he served alongside Justice Kennedy, who he also clerked for. So that's one and only. We don't typically see that, but very excited for that to have occurred. All right. So I know what you're probably asking. You're probably asking, how do we get to the court? How does the case get to the court? And in 1 second, I'll be happy to answer that. But what you should know is in between the court actually taking its seat from October 2022 to July, about 2023, there are sessions. And currently we are out of sessions. The next section does not begin until April 17th. So I thought you would be happy to know that. Also, when justices are in sessions, it's divided between sittings and recesses. So the sittings are where they actually hear cases and determine whether or not they will go forward, and recesses are where they complete their deliberations. Okay, so how does the case come to the Supreme Court? Well, this case comes to the Supreme Court through a legal instrument called a writ of certiorari. And a writ of certiorari really asks the court to review the record of a lower court. That could be a federal court or the highest state court. And about 7,000 to 10,000 cases, it just depends, 8,000 to 10,000 cases come up before the court, but that actually gets dwindled down to about 70 to 80 cases are actually heard by our justices. So your question is, how does that happen? Of course, that happens because some of the cases are just not accepted. The justices will review it, and it will require a certain number of justices to accept the case. So here's our time to do our interactive piece. In your chat, if you can, tell me how many justices are required for a case to be heard. How many justices are required for a case to be heard? Not to be decided, but to be heard. Are we seeing any answers in our chat, Jamie?
I don't see anything quite yet. So hopefully,
Okay.
there's, okay, a couple people actually are chiming in. So Ben
Excellent.
says 3, Elizabeth says 5.
Excellent. Those are really close. They're actually, it's required for 4 justices to agree. Now recall, there are 9 justices on the bench, but 4 out of the 9 must agree to hear the case. We call that the rule of 4. When 4 justices determine that this is an actual case that they believe has some constitutionality issues and will have some impact, they will hear the case. What's interesting to also note is that if the justices determine they do not want to hear the case, it does not mean that the justices have given any sort of opinion. They are simply saying that at this time, they are not interested as a whole to hear the case. And so what happens is the very last opinion that's out there remains the opinion of that particular case. So thank you for chiming in with that. There are some cases that we will see in a sort of direct appeal, meaning that there's no need for an official request. However, it still would go through a writ of certiorari, and those cases are typically death penalty cases. So those are what we call direct appeal. They go directly up. So now we have going from about 7,000 to 10,000 cases down to 70 or 80 cases. And I should also mention that sometimes those cases are combined. And there's some very interesting cases that you are already aware of, I'm quite sure, because this audience is sharp, I can already tell. One of those cases is Miranda versus Arizona. That case actually is not one case, but it's 4 cases in one. And so that is how cases are combined to reduce the numbers. Of course, we talked about opinions and how those come. There are different types of opinions. There is the majority opinion, which really requires at least a 5 to 4 vote. There are concurring opinions, whereby justices might agree to the majority opinion, but have a different take on why they agree, and they'll give their rationale. And then there's what we call dissenting opinions. And a dissenting opinion, it really is the justice's time that they set forth why they disagree and what legal basis, or for what legal basis there may be some different result in the future. So dissenting opinions have become as important as other opinions. And in fact, some of our most important standards that we use are found in dissenting opinions. The one that comes to mind is the reasonable suspicion definition, can be found in a dissenting opinion. Okay, moving right along. So in your chat, if you would spend a little bit of time with me and let's do a little check. When were the first justices? When did the first justices take the bench? Does anyone remember first justices? What year did the first justices take the bench? Anyone? Are we seeing any answers out there?
I'm not seeing anything quite yet.
No. It might take them a little bit of time. I flip back and forth, audience. So if you could stick with me.
Okay,
we'll
it
have
looks
to
like
see how
they're starting to kind of flood in. We have 3 people, which they must have been listening to earlier. They're saying 1790. They all say 1790 actually. So.
Excellent. 1790 is when our first justice took the bench. I think that this is particularly interesting and it calls for a story. So on February 1, 1790, our first justices came and were able and ready to serve their country. The only problem was only 3 justices showed up. So without the ability to actually have a quorum, they had to return the next day. So the first day of official business was February 2nd, 1790. Thought you might appreciate that. Now, that's interesting, but now we want to sort of discuss when did the first woman take the bench? And I like these numbers big and bold because what you're seeing before you is almost a 200-year gap when justices took the bench and when our first woman took the bench. In a second, you'll be able to razzle and dazzle me with who the first woman is, because I know you know it. But I would like to first just discuss the fact that there's been 42 years since a woman has taken a bench. That is not a very long time. Perhaps you might understand that there's been some significant change and increase in how we view the law in 42 years, but then some might say there's actually been some steps backwards. What I will say, though, is that what you should be most aware of is that there have been more than 25,000 opinions, only 146 were overturned, and women were only a part of that for the past 42 years. And the first woman, it took nearly 12 years to get to the second woman. So for 30 years, we've really had a gap. All righty. So my question then is, how many total women have we had on the bench? If you've been listening to any of this, and I'm sure you have because you showed me that with your answers before, you know that it's 6. How many total justices? 116, which means out of all of our justices that we have, there's been just 6 of the 116, 110 have been men. Now, that isn't problematic. However, I do think that the Supreme Court of the United States could very much benefit from voices of women in all different shapes and forms and different geographic areas, right? We're talking about diversity in a lot of ways. And so I hope to share some of that diversity, some of how the women who have come on the bench have shaped the bench in a second. I want you to consider as we go through our presentation, though, one important quote. How many lady justices will be enough on the bench? How many lady justices will be enough on the bench? We will return to that very important question in a second. But before we go there, there's time for another interactive question. So I'm going to give you a little bit of time to come to your computer to get ready to type. We're going to do what's called a chat storm. So I'll explain very quickly and briefly what a chat storm is. In a chat storm, you will type either A, B, or C, either A, B, or C, but you will not hit enter. In a chat storm, you will type either A, B, or C, but you will not hit enter. until I say hit enter. And that is to keep the integrity of our answers, okay? So here are your questions, and they're a little bit tough, but I think that you can handle it. Which one of the following statements is not true? Which one of the following statements is not true? Justice O'Connor started and led her own daily aerobics class and insisted that all of her clerks and staff join in. That's A. Remember, you're going to choose the following statement that's not true, but do not hit enter. The Supreme Court did not install a women's bathroom until Justice Ginsburg took the bench in 1993, 12 years after Justice O'Connor joined the court. And then, of course, C, while they were in law school together, Justice O'Connor and Chief Justice Rehnquist were engaged. So we're going to go through each one of these. You're going to sort of try and figure out the validity and tell me which statement is not true. I'll give you a couple minutes. Should we get a Jeopardy tune? Do, 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 do. Do 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 do. Now, Jamie, we are ready to start our chat storm.
Okay.
So if I am correct, we should start to see those coming up. Hit enter. Is it A? Is it
Oh,
B?
wow.
Is
Okay.
it
Yep.
C? Yes, it worked, Jamie.
It did
Exciting.
work, and it
We
looks
will
like
do the chat storm again. What are we seeing, Jamie?
most everyone has said C, and there is one A.
So they believe C isn't true or A. Let's take them one by one. If everyone is saying C, let's see. While they were in law school together, Justice O'Connor and Chief Justice Rehnquist were engaged. Well, actually, there is some validity to this particular point, but it just falls short of the truth. Justice Rehnquist, Chief Justice Rehnquist was very much involved with and wanted to marry Justice O'Connor. He did propose several times. Justice O'Connor did not marry him. But what's interesting to that story is Justice O'Connor and Chief Justice Rehnquist and their spouses later became great friends. In fact, Chief Justice Rehnquist invited Justice O'Connor when he took the bench, and her husband both showed up. And of course, she later took the bench. So they were excellent friends, almost always together, great conversation, but never engaged. So all who said C are exactly correct. I'm going to A now. Justice O'Connor started and led her own daily aerobics class and insisted that all of her clerks and staff join in. That is absolutely correct. She was an outdoors person, and she believed that everyone should constantly be in motion. Now, B is what's interesting. So it's really interesting to me that no one chose this. The Supreme Court did not install a women's bathroom until Justice Ginsburg took the bench in 93, 12 years after Justice O'Connor joined the court. Now, excuse me, but you tell me how upset you would be if where you worked did not have a women's bathroom for 12 years. These are the conditions in which Justice O'Connor worked under until, I guess, the court determined that there would be more women joining the bench, and Justice Ginsburg came. So that's something that's really interesting. Thank you guys for being so interactive. Here is our first woman Supreme Justice. Pictured here is Justice Sandra Day O'Connor, and we call her the first. That is a childhood picture. I thought you would want to know what she looked like earlier in life and later. As you already were aware, she was nominated by President Reagan, and that was done in 81. Look at how her Senate vote, right? We talked about the Senate Judiciary Committee and then the full vote in front of the Senate. It was 99-0, completely unanimous. This is really good because this is going to be our first woman on the bench, and we see that there's complete support from our senators. Now, I should tell you that Justice O'Connor was nominated, a woman nominated for the Supreme Court in fulfillment of a campaign promise. Yes, President Reagan, while he was campaigning, said that he would elevate a woman to the bench, and in fact, he did. Something else really important that just occurred for Justice O'Connor, who's now 93, she is one of USA Today's Women of the Year. So someone that I think you should know. Here she is later in life. Justice O'Connor is our first woman, as I previously said. She was reared in El Paso, Texas, born there, but raised on a ranch, really with her grandmother. She later went on to Stanford in 1950 and graduated Stanford Law, third in her class in 1952. And yes, you guessed it, who was also in her class in the #1 spot? None other than Chief Justice Rehnquist. So they were very connected from early on in their careers. Most individuals who work with Justice O'Connor, specifically in the state Senate, said that she was smarter, tougher, and more organized than any man around her. Notice that she graduated from a very prestigious law school and went on to actually become someone that was obviously great because she was elevated to the United States Supreme Court. But if you notice in her history, she was unable to get a job as an attorney immediately. In 1952, she worked for the county, but not as an attorney. Later, she went to Germany to try and get some experience. She comes back and becomes a state senator in Arizona, rises to a wonderful career and is elevated to the Arizona Supreme Court. And then she will go on to write a very important decision that I'll share with you in a minute. But Justice O'Connor really sort of came through some difficult times. She was the type of woman who could charm with her Southern charm, most just about any, but she had an extremely important work ethic that most could see. And so when you saw the 99-0 vote through the Senate, she did most of it through her charm and her dedication. Justice O'Connor wrote a very important opinion, and one in which most conservatives, and she was a conservative justice, would not have done so. You see there Planned Parenthood versus Casey from 1992. You'll note from Roe v. Wade in 1973, what most individuals think is the controlling law actually was controlled by Planned Parenthood that referenced Roe v. Wade. And in Justice O'Connor's opinion, in which she was joined by Justice Kennedy and Justice Souter, she announced the judgment for the court. And that ruling upheld abortion rights granted from Roe v. Wade and held that states could impose restrictions on abortion as long as they didn't pose and, quote, undue burden. So she introduced this additional layer that was to protect women and women's reproductive rights when it was not, something that was of importance or fame to do so as a conservative justice. But she greatly believed, and she stated that stare decisis, the principle of adhering to precedent, is really important. And that is why Roe v. Wade must be upheld. But she also noted that there were some restrictions, albeit slight restrictions. So that's Justice Sandra Day O'Connor. Who you see before you is actually Justice Ruth Bader Ginsburg. And in your chat, we're going to have another chat storm in a second. But I love this picture of her. She's a young top there, young little thing. Justice Ruth Bader Ginsburg, of course, was nominated by for President Clinton in 1993. If you look at her actual Senate vote, her full Senate vote, right? We recall that Justice O'Connor was 99-0, unanimous. And we start to see a little bit of movement, 96-3, but still a very good number to know that a woman is actually welcome on the Supreme Court of the United States. Now, here's your chat storm question. Remember, you're going to type your answer, and before I say hit enter, you'll wait a second. I'll let everyone have a chance to do so, and we'll start to read it. What is the first name of Justice Ginsburg? What is Justice Ginsburg's first name? We'll give you a couple seconds. Justice Ginsburg's first name. And I'm hoping you had a chance to come to your computer, to type out your answer, to say, is this person crazy? Of course, I know the first name of Justice Ginsburg. Perfect. So go ahead and type it in, and now you can hit enter. Are we starting to see any responses?
We are, yes.
Excellent. What is Justice Ginsburg's first name?
We have a lot of Ruths.
Ruth. That is so interesting. And you might think it's Ruth, but actually her first name is Joan. So you heard it here first, Joan. Her name is Joan Ruth Bader Ginsburg. In fact, her mother and her father named her Joan, but when they took her for the first day to kindergarten, there were so many Joans that the mother from that point decided to call her Ruth by her middle name. So technically, her first name is Joan. I'm not sure about you, but I thought that was interesting. So I thought I'd share that with you. All right, and here is RBG, or what we refer to her as the notorious RBG. She, of course, took the bench in 1993, but we'll talk a little bit about why she's nicknamed Notorious RBG. Perhaps you're familiar with a rap artist, Notorious B.I.G. And when Justice Ginsburg was interviewed, someone told her that he too was from Brooklyn. And from that very moment, they said that she was a lot like him, and they nicknamed her the Notorious RBG. And she loved that name. So I'm not sure she loved rap, but she loved the sort of pop icon status of being connected to that rapper. She was born in 1933 in Brooklyn, New York. And she has an interest in history with cancer. It sort of permeated her life. So much so that her mom actually died from cancer the day before she graduated high school. And instead of going to her graduation, she stayed home with her father and comforted him. So early on, you start to see sort of this aspect of her nurturing ability, specifically as it relates to cancer. In 1954, she graduated top of Cornell College. And in 1959, she graduated first from Columbia. What's interesting about Justice Ginsburg, Justice Joan Ruth Bader Ginsburg, is that she actually started at Harvard Law School. Yes, I know. I have there that she graduated first from Columbia Law, but she started first at Harvard Law. And because of her connection with her husband, and the fact that he received a job in another location, she actually moved with him and took up the mantle in Columbia and still graduated first. She was an editor in a law review in both places and was still first in her class. Prior to joining law school, she was married and had her child. Her husband did get sick with cancer during school. And so she actually stepped in as a first-year law student. He was a third-year law student. She would go to both classes and take notes and type up his paper. So she sort of received 2 law degrees, is the way I like to look at it. Interesting fact about Justice Ginsburg is that she also co-wrote a book regarding her workouts. She was well known for her workouts, called Body Justice. You can't beat that. Again, if you look at her history in 1959, She was unable still to receive an attorney position, although she graduated first. She went internationally, just like Justice Sandra Day O'Connor, went on to Rutgers School of Law and taught there. She presented before and argued before the Supreme Court of the United States under the ACLU 6 times. And she was the first tenured woman at Columbia Law, where she graduated first there as well. She was elevated to the DC Court of Appeals, and she actually wrote one of her most important cases. And for our time, I'm going to let you know that this was a case where she simply would talk about how the courts related to the setup for Republicans and the state house. And in Virginia House of Delegates, they talked about the district plan and racial gerrymandering, which is something that we look at today. A quick fact about Justice Ginsburg is that she failed her driver's license test 5 times, and inadvertently, in trying to stay away from Justice O'Connor's car, she hit Justice Scalia. I'm sorry, stay away from Justice Scalia's car. She hit Justice O'Connor's car. So that's a quick tidbit about her. And then there were 2, and we were excited to have 2. Here you have before you Justice Sonia Sotomayor. She was nominated by President Obama. And if you look at her vote, now you start to recognize that it is going to get a little bit more partisan. We're starting to see that having the credentials is no longer going to be enough. We start to see that there's probably going to be some issue. Now, Justice Sonia Sotomayor was the youngest, at the time, the youngest judge in the Southern District. And she was no more than 38 years old. She's a lifelong New York Yankees fan. And here is her credentials. I will allow you to read that. I'm going to share with you some important facts. She likes to call herself the first Latina. So I identify the way that she does. She's very excited about go-karts. She says that she's a kid at heart and she does a lot of go-karting. She also had diabetes as a child and was in and out of the hospital until age 7. Was raised by a single mom after age 9 because her dad died, and grew up in the Bronx. So she would want you to know that she's came through some hard times, but always persevered. And as you can see, she graduated summa cum laude from Princeton and took up the mantle of equity very early in her career. So if you notice, this is going to be our first justice who actually gets a job right out of law school, our first woman justice, and that's going to be assistant DA. Then she goes into private practice. She's elevated to judge, and she goes to the Court of Appeal. Something that's really interesting to note about Justice Sonia Sotomayor is the fact that she always was there to make sure that those who were less fortunate had a voice. And when she was at Princeton, she alleged that discrimination was going through, and she led rallies and so forth to draw attention to it. So one of her important cases is Cruz versus Arizona. And that just occurred on February 22nd, where SCOTUS ruled in favor of a convicted murderer seeking to overturn a death penalty sentence. And she had a hand in that. And she spoke to this concept of future dangerousness. So that's a case that you might be aware of, something that her justice journey has brought her to. And then there were 3. This is going to be the first time that not only we have 3 women, but 3 women on the bench at the same time. And there was a repeat of something that Justice O'Connor wrote, Justice Ginsburg, after her first opinion. Justice O'Connor said it was a very fine opinion, and she looks forward to seeing many, many more opinions. And that was repeated with Justice Ginsburg and each justice, female justice afterwards. So we're really excited for that. Now, here is another interactive question, one that'll help us get through our remaining justices. Which one of the following statements is not true? Remember, this is a chat storm, so you shouldn't send it out right away. A is Justice Marshall, nicknamed Justice Kagan, Shorty, and Chief Justice Berger, Chiefy Baby. B, Justice Kagan is a huge fan of comic book superhero Spider-Man. Or C, Justice Kagan tore a knee ligament during Justice O'Connor's morning aerobics class. So we'll give you a couple seconds to do that. And if you would go to your chat and type in A, B, or C, I will say, go ahead and hit enter. Jamie, are we seeing any responses there?
They are flooding in. Let me go back and see. We have A, B, A, and B. So a little bit split there. And
no one likes C.
And there's a C.
Okay, which
C
one
just
is not true? Justice Marshall, nicknamed Justice Kagan Shorty, and Chief Justice Berger, Chiefy Baby, that is absolutely true. Justice Marshall, Thurgood Marshall, liked to really sort of joke around, and in his joking, he nicknamed each person, and Justice Kagan was Shorty, and Chief Justice Berger, Chiefy Baby. So Justice Kagan B is actually really a huge fan of comic book superhero Superman. That's one of her favorites. That's absolutely true. So that leaves us with C. Justice Kagan tore a knee ligament during Justice O'Connor's morning aerobics class. And actually, there's, of course, some truth and some not so true. Justice Kagan did tear a knee ligament, but she did so while she was playing basketball because that's what she liked to do. And when Justice O'Connor saw her kind of coming in, she said that would have never happened had you joined my aerobics class. So there you have it. Justice Kagan is, I think, one of those justices that we don't spend a lot of time on, but who is very important. And I'd like to show you why I think so. Justice Kagan was nominated by President Obama. And again, you start to see her Senate vote, 63-37, recognizing her credentials and still supporting and knowing that a woman on the bench is important. Here are her credentials, and they're very fine credentials. One thing that you should know about Justice Kagan is that she reread Jane Austen's Pride and Prejudice every single year. She liked to really read that. She is the youngest at the time sitting justice that comes to the bench. And she is going to be the only justice that does not have any prior judicial experience. But that should not make you think that she's not qualified. On the exact opposite, she's very qualified. So she was born in the Bronx. She went to Princeton, then went to Oxford and graduated Harvard Law. She clerked for Justice Thurgood Marshall and did believe a lot of his judicial philosophy, but also developed her own. She was a law professor at U of C when former President Obama was also a law professor. She then went on to become a Harvard professor, and she becomes the first female dean of Harvard Law. She also becomes the first female solicitor general. This is a huge thing. Solicitor generals are the persons that represent the United States in the United States Supreme Court, and she becomes the first woman who heads up that particular office and department. And of course, one case that really deserves noting is Miller versus Alabama. And it's where Justice Kagan raises the alarm about how we should view juveniles. So in opinion 5-4, she notes the Eighth Amendment's prohibition of cruel and unusual punishment forbids a sentencing scheme that mandates life in prison without possibility of parole for juvenile homicide offenders. And that work in Miller versus Alabama then is used as a foundation to further advocate for juveniles. and you'll see some of that. And then there were 4. And in fact, when there were 4, we see all of the women gather for Justice O'Connor when she received the Seneca Women Global Leadership Award. And so that's a pretty exciting time to see 4 women. You notice that Justice O'Connor is in a suit, not a robe, because she's no longer on the bench. And then there's Justice Amy Barrett. I informed you that she likes to be called just Justice Amy Barrett, not Coney. I try to respect how individuals like to be called. She, of course, was nominated by Trump, President Trump. And if you look at her Senate vote, we're starting to see extra movement. So this was a very contentious vote, to say the least, 52 to 48. But we also start to note that Justice Barrett was the fastest justice who moved through the Senate process, through Judiciary Committee and so forth, 30 days from nomination to actual elevation to the bench. So that's pretty uncommon. Justice Barrett grew up in New Orleans. She was the oldest of 8 children, and she actually has 7 children. Her youngest child has Down syndrome, and of course, she adopted 2 children from Haiti. So those are some interesting facts about her. She is the youngest justice on the bench, and she also is the only woman who's ever been on the 7th Circuit, which is in fact our circuit, the only woman on that circuit. She's a Rhodes College magna cum laude graduate, Notre Dame Law School summa cum laude. She was the only justice in our history to have received a distinguished professor 3 times by students. So I thought that was something that we should all know. She, of course, clerked for Justice Scalia and believed and assumed a lot of his judicial philosophy. She went into private practice, then later became a Notre Dame law professor, where she received that distinguished professorship award 3 times. And she actually she concurred in the Dobbs decision, but did not write it. Another case that might be of interest that she did weigh in on is Bruin, New York versus Bruin. And in that particular case, New York passed the state law restricting the ability to carry long guns. And she concurred in the majority opinion, stating that today's decision should not be understood to endorse free will reliance on historical promise from mid to late 19th century to establish the original meaning of the Bill of Rights. She wanted to be clear that the judicial philosophy that she held so true would carry over, that this particular opinion did not state something different. And then there were 5, but of course there were not 5 on the bench. We then had just 3 justices, 3 female justices at once. And of course, last but not least, we have just Justice Ketanji Brown Jackson. And she was nominated by President Biden, who again, this was in fulfillment of a campaign promise to nominate a woman, a Black woman, in fact, to the bench. And he did just that. Again, if you look at the Senate vote, that is very much along partisan lines. So we start to see a complete difference from the 99-0 that Justice O'Connor received to our latest justice, 53 to 47. She was reared in DC and went to Harvard University and graduated magna cum laude. She actually was partners with Matt Damon because they were classmates. So in a drama course, she was his partner, and she went on to be at Harvard Law, graduated cum laude, and was the editor of the Harvard Law Review. You can see her career as it unfolds. If you notice, Justice Jackson is the first of many things. Something that I think you should find the most important first that she has is no. Not that she's the first African American, but if you look at the fourth bullet, you'll see that she's the assistant federal public defender. And that is going to be her uniqueness that she brings to the bench, in addition to being African American. I like people to know that she is the first public defender to grace the bench. So she comes with a very distinct background, one in which allows for her and makes room for her to actually state the most words of any justice, 1,300 to be exact. Most justices speak about 1,000 words, but she does 1,300 because she brings a unique sort of background. And Justice Ketanji Brown Jackson was elevated to the DC Circuit Court of Appeals, and then she has some dissenting arguments. She makes a very compelling oral argument in Merrill versus Milligan. We have not received that opinion, but she talks about her judicial philosophy, which she uses the originalist approach and then sort of puts that a modern application to it. So it'll be interesting to see what the actual opinion comes out to be. And so here are your six. And I wanted to just wrap up by giving you sort of this view of six very important women who have come to the bench with varied backgrounds, first in a lot of ways, but have really built sort of this aspect of what the United States Supreme Court and its laws and constitution may mean to women as well. And so I leave you with this thought, one in which we started with. One woman was sometimes asked, when will there be enough women on the Supreme Court? And if you're familiar, you know, her answer was, when there are 9. People are shocked, but there have been 9 men, and nobody's ever raised a question about that. Of course, that's going to be Justice Joan Ruth Bader Ginsburg, the notorious RBG. And now, if you have questions, I'll take those. Thank you for sticking with me.
All right, so let's see. I don't see any questions quite yet, but let's give it a couple minutes here. This was great, really informative, and wow, the time went by really fast.
I was so concerned because there's so much to share and nuances to do so, and this information is so important that we want to get through it. So I'm hoping that people were able to kind of receive as we went through the information.
Yeah, for sure. Okay, we do have some questions coming in. I don't know if you could see that. Mark is
Yes.
wondering.
Do you know if the justices have security details? So that's really interesting. If you remember, at some point, not only did the justices have security details, but the building itself had security details. I think that this is important. Now, is there some sort of, I think your question may be leading more to Capitol Police. And if you're familiar, there are about 40 different types of police departments that deal with the White House and so forth. So on any given day, security is there. Their specific details, I do not believe they have specific details, but there is general security present. Which justice had the greatest impact in your life? Tristan, I don't think I've ever been asked that, Elizabeth. That's a beautiful question. I think if I had to pinpoint it, it would really be Justice Kagan. And it's because people actually kind of write Justice Kagan off. They don't understand the fact that she had no judicial experience, but that she was able to really reach to these highest levels. And another thing about Justice Kagan is that she was supposed to have the position, she was supposed to be elevated to the Court of Appeals when Chief Justice Roberts received her seat. So I think her patience and her tenacity to continue to practice has really been impactful. Who I'm most aligned with, I would say, Elizabeth, is Justice Brown Jackson, because of her nuanced approach to justice. She is going to be one of the solo voices that actually speak to what 40,000 Americans already know, that there are two sides to every case. And so I'm very impressed by her. I hope that answered your question. Lisa says, when was the first female clerk to the Supreme Court? And that was Justice Kagan, right? That was Justice Kagan, who was going to be at least amongst our lady justices to reach that level. What do you think about Justice Clarence Thomas and his recent controversy about receiving gifts and vacations, et cetera? I guess what I would say is Justice Clarence Thomas has been quiet for so long. It's amazing to hear him speak about anything. And no doubt when he speaks, he's speaking about controversy. So I find that quite interesting. I think that when we start to talk about gifts, we need to have some sort of approach to all of our justices. Our Supreme Court justices are the only ones who do not have an ethical platform that they must adhere to. Every other justice or judge must. And I think if we're going to get to the root of this controversy over gifts and vacations, we actually need to have some sort of comprehensive approach to those things. Now, Ben, I think you should know that Justice Thomas is the one in the news, but there have been some of these same whisperings about Chief Justice Roberts. I'm just putting that out there. Mike, your question is today's court as divisive politically as the Congress? That's an interesting question, because I like to say that justices lean a certain way. Not that they are, Democrat or they are Republican, but they lean in a certain way. But there's no doubt about it that in order for the court to really gain its legitimacy, they're going to have to try to refrain from saying a lot of the things that would divide the court. As far as opinions that are being released, I think this is actually adding fuel to the fire to the divisive political state that we find ourselves in. But I'm hoping that law will win out, Mike. I'm hoping law will win out. So far, not so good, but stay tuned. Lisa, your husband was a Supreme Court clerk. The justices indeed get security. Anonymous comment. Okay. Okay, not sure about that. But the justices do get security. I think what his question was, do they get a security detail? Do they get a specific security detail? And so that was what I was speaking to, that you have to know there are a lot of agencies that actually support them as well. Okay, sounds good. Any other questions?
Actually have a question if I could pop in really quick.
Yeah.
So do you think that there should be term limits for justices?
So when we talk about term limits, I think what we have to do is think about sort of what the purpose of a term limit is. And I think I didn't have the opportunity or the chance to share with you about Justice Joan Ruth Bader Ginsburg, but she was able to stay attuned and focused for 25 years, never missing a moment on the bench. As long as a justice remains in a position in which they are able to focus, right? We do not nominate and then confirm them for what their opinion is. We do so for their credentialing. So if their credentialing is present, then what we also would want to do is make sure that they stay there. For me, I think it's very important to have a mixture, an intergenerational, multicultural, sort of intertwined representative of what our country looks like. So I guess that's my long way of saying, Perhaps, Jamie. It just really depends on who the justice is. For example, our oldest justice is Justice Thomas. He seems to still be in tune. Now, you may not like what he's saying, but the fact is that his credentialing and his ability to reason, I don't think has been has had any impact with regard to his age. So I think that they're fine not having that. And of course, the whole point of not having a term limit is to make sure that justices are able to rule in the way in which they would want to, if that makes sense, without any repercussions politically.
Right. Great. Well, this is so informative. And as I said before, the time just flew by. I feel like we could just keep talking for another couple hours, but of course, everybody needs to go to bed pretty soon. So I wanted to let everyone know about a program that we have coming up on Saturday, April 15th. Kind of a fun program. We're back in the library doing programs. I'm glad that we can provide things virtually. This is really great for flexibility, but we also like to do in person. So we're doing an 1850s tasting history program where we will travel back in time to discover the tools, recipes, and ingredients used in Illinois in the late 1850s, right around the time that Lincoln was debating Douglas. So we are excited about that. We will, yes, actually be tasting some of the recipes. So that'll be fun. So go ahead and register for that one. We still have some space available. All right. Well,
Jamie, if I could add one last thing.
Yes.
Quick search on June 14th, 2022, after much delay, the House of Representatives passed S 4160, a bill to provide round-the-clock police protection for Supreme Court justices and their families. That was just passed in June of 2022.
Okay.
So your question and answer, Mike. There you have it.
Thank you. Appreciate that.
You're welcome.
All right. Well, this was great.
You,
yeah, you guys have a great night and thank you for joining us.
have a great day. Thank you, everyone.
Thanks.